Could start.
Okay, sir. Yeah. A very pleasant afternoon, everyone. In order to excel in anything, the mantra is quit talking and begin doing. I am Nandini J, Assistant Professor, Department of Commerce, on behalf of Unnathi, an initiative for student and faculty development, and on behalf of SSMRV College, welcomes each and every one for two-day national level webinar on intellectual property rights. In yesterday's session, we got the insights on intellectual property rights and its protection. Now, we will be having the session on the topic an overview of intellectual property rights, concepts and cases by Mr. Harish N, Senior Advocate, Member BPAC, Visiting Faculty at SSMRV College. I now call upon Mrs. Anushayan, Assistant Professor, Department of Commerce, to welcome the gathering. Over to you, ma'am.
Good afternoon, everyone. Thank you, each and every one of you, for being joined here with us today. We are pleased to be able to welcome those of you that have been with us for a very long time. I take this opportunity to welcome each one of you. I, on behalf of our esteemed institution, SSMRV College, extend a warm welcome to today's resource person, Shri Harish, advocate, member, BPAC, visiting faculty, SSMRV College. A warm welcome to you, sir. Thanks for accepting our invite in your busy schedule, and I
Thank
extend
you.
warm welcome to you. It's with great pleasure I welcome our respected principal, Dr. S. Anil Kumar, sir, who is a true spirit behind all our initiatives. Thank you, sir, for your support, and a warm welcome to you, sir.
Thank you.
It's indeed pleasure to welcome Coordinator IQAC, Head Department of Commerce, Dr. M.S. Nagaraj, sir, who is a supporting factor in all our events. Thank you so much, sir, for your endless support. I'm very happy to welcome all the teaching fraternity from SSMRV College, technical team of SSMRV College, and the participants across India. I'm very glad to welcome all of you for today's session. Thanks for joining with us, and a very warm welcome to one and all present here. Thank you.
Thank you, ma'am. We welcome you also for the gathering. A visionary may see, but a leader must decide. One such visionary, leader, and master who directs his people for their betterment by providing various opportunities is none other than our ever charming principal, Dr. S. Anil Kumar. I request our beloved principal to address the gathering. Over to you, sir.
Thank you, Professor Nandini. Um, Good afternoon. Today we are on the second day of the national level webinar on intellectual rights by Professor and Harish. And very happy to have him as a resource person for this particular webinar for various reasons, because he is an expert in this field and he is a friend and well-wisher of our institution. And of course, uh, we are also very happy that lot of participants or actively participating in all our initiatives because of the kind of resource persons we identify. So one such resource person is with us, Mr. Harish, on behalf of college, RV Educational Institution, and my own behalf. Once again, I would like to welcome you, sir.
Thank you, sir.
And today's topic is very interesting. It is on IPR concepts and cases. I think cases will if you discuss on various cases, I think it will be more interesting. So participant will get an opportunity to listen to a lot of cases so that it will really help you to understand better, especially for non-law school students and faculty. Because in law schools, it is part of the curriculum. But for non-law schools, like students of our college and similar colleges where where BCom, BBA, BCA courses are run, I think it will be of great insight for them to know more about IPR. So I would like to really, once again appreciate the initiative taken by Unnathi, Department of Commerce, and the HOD and QSC uh, coordinator, Dr. Nagaraj, and the co-convener of this particular webinar, Professor Anusha, and her entire team of faculty and students in organizing this particular. Thank you so much.
Thank you, sir. You always motivates us by your inspiring words. I now call upon Mr. Ajay Kumar, Assistant Professor, Department of Commerce, to introduce our resource person for the day.
I would humbly request one line introduction to save time, because I'm not an outsider here. So I think most of them know me here. So let's give more time.
Very good afternoon to one and all present here. Respected Principal Sir,
one line.
resource person for the day, Harish Sir, faculty members, my colleagues, participants across India. Harish Sir is a legal professional for about 3 decades, and he is an expert on constitutional law, electoral reforms, parliamentary procedure, and real estate law. Sir is a legal advisor for various property developers, educational institutions, and also an expert on parliamentary procedure and a socio-political analyst. I must mention a few of his achievements. In 1990, Sir was a delegate at the Commonwealth Parliamentary Conference organized by the Commonwealth Parliamentary Association of Karnataka, which was held in Vidhana Saudha. Sir has presented various papers at national level seminars, a few of them on institutionalization of Lok Adalat system in India, which was presented at a national seminar held in Mysore in 1990. A paper titled Secularism in Crisis, a Youth Response, which was presented at a national level seminar again in Bombay in 1993, which was organized in the backdrop of Babri Masjid demolition and the Bombay bomb blast. Apart from legal professions, Sir imparts professional training to students for debates, moot courts, public speaking, personality development, model parliament competitions, model United Nations, and many more. He is the resource cum mentor for all model parliament competitions by YMCA and various schools, colleges, social organizations all over the country. Sir is a judge for various moot court competitions, both at regional and national level. Sir has a passion for teaching and training youngsters and students in the art of learning. He has adopted innovative ways of teaching. His teaching are always backed by video presentation on any subject that he takes. And Sir has also titled a book, An Introductory Guide to Parliamentary Procedure for Students. Sir is an active member of Bangalore Political Action Committee, which is popularly known as BPAC, which is headed by Mrs. Kiran Majumdar Shah of Biocon, which interacts with government and its agencies suggesting reforms for good governance in the state in general and for a better Bangalore in particular. He is involved in process of suggesting electoral, legal, parliamentary reforms and also creating awareness among the youth on value of voting and their participation in policy making and governance in world's largest democracy. I just contain my a few words about Sir. Sir has also been nicknamed a mobile encyclopedia. So it's a privilege to have you with us, Sir. Thank you so much. I'm also happy to introduce. He was also my professor at SSMRV when I was studying. Thank you very much, sir.
Thank you for the introduction.
Hello, sir. So now you can take up the session. Over to you, sir. Hello, Harish, sir.
I am starting.
Yeah, okay.
I can share the. You're able to see the screen?
Yes, sir.
Okay.
It's visible.
Respected Principal, Dr. Anil Kumar, respected Head of the Department of Commerce, MS Nagraj, respected faculty members of all the streams of the courses in SSMRV College, HODs of BBA, BCA, participants who have gathered here for this afternoon's webinar, and my dear students of SSMRV College and students of other colleges who are participating in this two-day webinar on IPR law. I deem it a great privilege to be with you all this afternoon. And I will also, I will be failing in my duty if I do not show my regards to the Unnathi team, who has been instrumental in organizing this two-day webinars on the intellectual property laws. Yesterday, I think Mr. Ramratan, Professor Ramratan has dealt upon protection of IPR law, and today we will take you down the gamut of the IPR law concept and cases. Cases as simpler it could be. I will try to present it so that the students, because of not being from the law stream, they may find it difficult to digest the legal jargon and the nuances of the entire gamut of the IPR law. IPR law, as the word itself says, intellectual property. Okay, citizens of this country have got a lot of rights and maximum freedom as far as a lot of rights enshrined in the Constitution are concerned. And intellectual property means property which is pertaining to the knowledge area, the arena of knowledge. We used to always hear the words, it's called knowledge is divine. And today it is not just knowledge is divine. Today information is divine. Any information, we are in the information technology era. So information is divine. Any information, good or bad, has got its utility value in one way or the other. Even a good information about a bad habit to alert people not to get hooked by the bad habit is also a good information. Statutory warning on several packets of cigarettes and on alcoholic drinks which you get to see is a warning, which is a good information about a bad habit which they may get hooked up to. So in this era of information technology, every information has got its utility value in the human society. And intellectual property is one of the intangible properties when compared to the real estate properties, which are well known to people in this country. IPR law covers a lot of areas of statutes which are enacted by the Parliament of India, and also covers various international conventions, treaties to which India is a signatory. I will not go in detail with all those conventions and treaties. We will just run you down the various important laws: the copyright law, trademark law, patent law, design act, and various other laws which are allied laws, which are also part of the intellectual property regime in India. Intellectual property regime in India has got various laws and various areas which it governs. It governs the patent law, trademark law, copyright law, plant and variety law, the geographical indication, trade secrets, etc. These are all part of the various areas which are covered by the IPR law in India. Among these areas, the various acts which are part of the IPR regime is the Copyright Act, Patents Act, Trademark Act, Geographical Indication of Goods Registration and Protection Act, Designs Act, Protection of Plant Varieties and Farmers Act. In the other two last acts are also well connected today because of the area of the IT sector. Everything which is there on the domain of the information technology also fits into the IPR regime. Your software, source code, all these things also fit into this IPR regime. Information Technology Act. The latest is the other act which is now gaining momentum in India with Modi, the having inaugurated the semiconductor integrated circuit layout designs and the conference on which subsequently the government of Karnataka has recently in the last 10 days perhaps has announced that a plant will be set up in Mysore in order to see that semiconductor integrated circuits designing happens in our state. So these are important and directly connected laws of the IPR regime. There are several other allied laws which need to be referred when you are doing in a particular sphere of activity of trade, commerce, in this knowledge-driven, economic-driven era. As far as globalization is concerned and sustainable development of the entire nation is concerned. Agricultural Produce Grade and Marking Act. This is called the Ag Mark, which you get to see on a lot of products, the Ag Mark. Antiquities and Art Treasure. See, the art is very important part of it. There may be age-old artifacts which may have got trademark, which may have got copyrights, and things like that. So the information technology, I think these two are repeated here. The Competition Act. Earlier you had Monopolist Restrictive Trade Practice Act. Then you had General Agreement on Trade and Tariff. If things is at global level, today you have the Competition Act because of the competition which you get to see in the economic arena, which covers various trade and practices and occupations. In Biological Diversity Act, you have plant variety and other areas of IPR. So these are all connected laws which you need to do. Consumer Protection Act of 2019, which has replaced the earlier Consumer Protection Act of 1986. Which Consumer Protection Act also, you can, when a product is misled and you're made to make a wrong choice or an improper informed choice, then you get to go to Consumer Protection Act also. So that may be also part of the unfair trade practices and things like that. So these are all connected acts which you need to probably refer now and then when you are dealing with IPR laws also. The general laws which are always available in addition to this, on which when you go to court and try to enforce your IPR rights, are the constitutional law when you go to High Court and Supreme Court provisions. Then the Indian Penal Code, the Evidence Act this is the most trickiest one, and in IPR is to lead evidence and to protect a particular trademark right and to establish that the design, patents and these things are all being infringed upon by the violators or by your opponent or your competitors in the field. Civil Procedure Code, because you need to go to civil court on these matters of infringement. Criminal Procedure Code when you take action on penal action, and the Amendment Act and so on and so forth. These are basically the general arena of laws which revolve around the IPR regime in India. The important, significant core acts are the Copyrights Act. Areas are copyrights, trademarks, geographical indication, the GI tag, industrial designs, and the patents, layout of designs and indicated tools. That's the semiconductor one. Even today's paper you get to see on the semiconductor issue being there in the newspaper. These are the core areas of the IPR laws. The international treaties and reciprocal agreements and conventions to which India is a signatory, where we recognize our people, the other nations' IPR rights. And our citizens and who have IPR rights here have a reciprocal recognition in the other parts of the world, where all the member states pertaining to these conventions are signatories. Is the 1961 Rome Convention on Protection of Performers, Producers of Phonograms and Broadcasting Organization. This deals with this copyright area also, where your sound recording and broadcasting, all these things and performances and rights of coming under IPR needs to be protected uniformly all over the world among the member states who are signatories to this convention. 67 Paris Convention for protection of industrial property on patents and trademarks are covered under this particular convention. 71 Berne Convention and for protection of literary and artistic works, which pertains to copyright law. Under the 89 Madrid Protocol, single trademark application can be filed for seeking protection on IPR law in multiple countries within the jurisdiction of the member states who are signatories to this Madrid Protocol. The TRIPS agreement, the end of 1994, TRIPS is a trade-related aspects of intellectual property rights agreement, and which is an important agreement, and which has been spearheaded by the World Trade Organizations on trade-related aspects. A patent cooperation treaty. It is a single patent application for different jurisdictions, like how we did in the Madrid Protocol. The WIPO Treaty, World Intellectual Property Organization, is WIPO, is World Intellectual Property Organization Treaty is that, which covers phonogram, copyright, performances, etc. These are where the international covenants and agreements to which India is a signatory, and we need to reciprocate to the nations who are member states of this particular these conventions and treaties. In copyright law, we start with copyright law, then go down to trademark law, then and the patent law, then the Design Act, and if time permits, the other area of plant varieties also. So we will try to give you a bird's eye view, an overview is what the title says, and also give you some illustrations of cases and case studies as to how these things have been infringed and protected in case of infringements time and again. In areas covered by copyright see, copyright is today what is happening in this country and what is happening in our own state. It is not copyright, it is the right to copy. It has become in the scams which are happening now, which are out in the media, which you get to hear on daily basis, is in these exam scams and other things. Copyright is a protection given under the Copyright Act to creative works, anything put on paper. Anything you put on paper, if it has originality and creativity and none else has done this before, then you will have a copyright over that particular writing. Anything scribed on paper, scripted on paper, ordinary drawing, which is different from all others. You get to see a lot of artifacts and arts exhibition. You have a Venkatappa Art Gallery next to the Vishweshwara Technological Museum. You have the modern art gallery in Manikyavellu Mansion area in Palace Road, adjoining the petrol bunk at the junction of the circle which leads to Mount Carmel College from High Grounds and Balabri Guest House downwards. So these literary works, what are all the creative works which get covered by copyright law? Literary works, which are books, computer programs, data, how you create your source code, or all these areas which are part of the works done, and through intellectual ideas which you would have conceptualized and then put it on paper or on the system when it comes to computer and other gadgets which you are daily using or acquainted with. Next is dramatic works, performances. There's a dance performance, Yakshagana. If you remember some particular Yakshagana, right? Dr. Shivram Karanth had a copyright over it. So if you Google, you may probably get those details on the Yakshagana performances and things like that. Musical works, lyrics, composition of music. The musicians who are part of it will have the right. The lyricist will have right. The singer will get right for the song which he sings. He'll have copyright. Lyrics gets right for the lyrics written by him. Artistic works are craftsmanship, sculpture, artifacts, your carvings, wood carvings, Chanpatna toys, the wall hangings, all this skilled work, skilled skill, labor, and commercial viability. These three things are important in the copyright law and in the IPR regime itself. Movies and sound recordings. A producer, excuse me, pardon me. A writer of a book, okay, allows a producer of a movie to adapt this particular book to make a movie. The writer had the copyright for the book. The producer gets the copyright for the movie which he makes. So and today you have OTT platforms, you have various media platforms on which all these things are portrayed and displayed onto public domain in either through specific events or through a general event also. Okay, artistic works, sculptures, artifacts, movie sound recordings also the audio visuals are part of this particular copyright law. Right, there is a society, Indian Performers a society, right, through which all these people who have copyrights on sound recordings, things, the singers, famous singers, all their recordings which are having copyright protection. Action, people need to take license from that particular society to play these musics, to play these songs in a public place is or for commercial exploitation. And unless if you're playing it inside your house, you don't need to do that. But in bars and restaurants also, people take licenses for such things. And there are several societies in Bangalore. Also, you have a public performance license to be obtained, and from a phonographic performance limited. I can show you that certificate after the presentation is over, which is taken by bars and restaurants to play these copyrighted versions of the music and songs in their commercial activity of their trade. Adaptations, translations, compilation. When somebody a book written in Kannada then gets translated into English, the person who translates this, then he has a right to get this translated version also copyrighted. Compilation with some new methods in compiling it, arranging data on a system in a particular manner which is different from some others who had never done it before. That also gets copyright. Right? Data analytics, all these things are today part of this copyright law. You have symbols of copyright and trademark. Together I've shown you here. The C is the symbol which signifies that if this is written in a book, in a second page or third page of a book or the back cover of the book, you get to see this word C encircled, which means in the copyright. Copyright is not mandatorily registered, but whatever you have written, the moment you put it on paper, and if there is originality and creativity, that day you get the right of having copyright. Right? Okay. Unlike trademark, which is mandatorily registrable, this R is in encircled next to that C, means it's a registered copyright. See, I told you copyright is not mandatorily registrable, so if it is registered, they will also show this R there at times. Times TM is R, TM, and next to it if there is R, then it's a registered trademark. So this is how the symbols will signify that there is a copyright registration done and by the author of the book or author of this literary works or craftsmanship and artists. It is who are involved in this creative work of knowledge, and to ensure that the culture, rich composite culture of Indian diverse society, it gets recognition globally as well as locally. Really. See, identity marks and copyright law C is already there. This FU is there in the second one. This is FU, fair use. Fair use. Okay. Somebody's copyrighted thing you are using to teach, to make comments, to teach, to criticize, to report by media, okay, all these things, and to do research work. If you are using some copyrighted material for doing these categories of work, this is treated as fair use. You will not be held for violation of copyright law. Okay, there is no infringement of copyright in this, because you will be using this for some research work. Media is using several things for reporting. These are all part of the fair use. So these are the exemptions available, so that people don't unnecessarily get into the trap of infringement of copyrights. Okay, this is that fair use. This is F and U together, which is a combo, which is fair use. Fair use. Very rarely you get to see these marks, but these are things which are there. Copyrights law. There is a copyright. It has got copyright has got a lifetime span. The protection period of a copyright protection, and to all these categories of people who are involved in all these above categories of works, is a lifetime of the author or the creator, and 60 years thereafter. Okay, suppose a person has taken a copyright, has got copyright right in 2000, okay, and he dies in 2030. Okay, then 60 years from 2030, nobody else can copy that and try to infringe this copyright. So 60 years after the lifetime of the author. Okay, so that is why these adaptations, translations are all continuing to happen and at times and in different version. Okay, you can't reproduce a book which is written today by the author and he dies in 2030 and it is copyright. So nobody can write that book again. So this is how the copyright protection is. But the adaptations of those books are made into movies later on. That's a different aspect, because there the producer gets the copyright, right? Okay, the producer gets the copyright. That's in a different form. This is in the same book form. You can't rewrite that, because the copyright protection carries forward after the death of the author for another period of 60 years. So that's the protection period available to the creator of the original work. Copyright case studies is just a few of them, just as an example. Hollywood movie Independence Day, a man in Mysore filed a case against the Hollywood movie maker and the script writer, saying that this Independence Day movie original script was his. Okay, but he was not able to show proper evidence and the case got dismissed. But this is how a small issue of a script or a screenplay and script of that particular movie went to courts from Mysore, where a man claimed that he had the copyright over the entire script of the movie Independence Day. Okay, however, the case was dismissed and there was no relief given to him. And so this is the copyright protection. How do you identify there is copyright violation? In copyright violation, the identification is to find out what is the difference between the original author's work and the other person who has actually copied this original author's work and created another book or created another artifact or created another sculpture and things like that. So when you compare these two things of the original creator and the person who has copied it, You will have to find out what is the difference between these two works. Okay, so once you are able to establish the difference between these two works, then you will know that it is not similar to the original work, or is it similar to to this original work. So that is how they decide on whether there is copyright infringement or not. But computer, social media, games. The computer software, I told you, you are arranging data in a particular manner which is different from the other people, then you have a right to have copyright over it. Social media games, you have a lot of computer games. The source code, if the source code is copied, then only you are able to tell that there is copyright infringement. This is a very difficult task, because one is when the people go to court, even the judiciary is not having that expertise to look at these nuances, the intricacies of these computer software and source coding material and the gaming software and things like that. Suppose a person clicks a picture. Okay, I ask somebody to click a picture. Okay, and then he uploads, the person who clicks the picture uploads it. I think you should there is a serial which is now being telecast every day between 9 to 9:30 on Sony channel. Okay, the name of the character there is Arman Oberoi, and Soumya is the wife of this character. Some onlooker of this businessman Oberoi in a public place, that onlooker, two girls click a photograph of this Arman Oberoi, who is standing with some other lady whose face is not visible, and this lady uploads it on the social media. Okay, and that so because of the social media, the wife gets to know that the husband had lied and gone to another place instead of going to the workplace or to his friend's house. So he went to his friend's house, he went away immediately. So that's created problem now. So in such a case, is what happens is, without the consent of the person, if somebody clicks a photo and uploads it, uploads it, then that can be questioned also. Question is whether it applies, whether it amounts to copyright or not, is $1 million question. That's a different area which is yet to be. This is a gray area on which social media, a lot of things need to be still streamlined under the IPR law and even under the general laws also. But if I have asked him to click a photo and upload it, then there is no question of any violation of any copyright. The other side of it, I'll tell you, is Mike Tyson. Mike Tyson has got a lot of tattoos on his body. Okay, though the tattoos are done at his instance, which are unique and different from the regularly publicly available pictures or artworks available on public domain. A lot of people do Shiva, a lot of the people do Trishula, a lot of people have different cobra tattoo, a lot of these things. There's no question of anybody, the person on whom this tattoo is done, he cannot claim a copyright over it. The artist has the copyright over these, and these are general pictures, so there is no question of copyright violation or copyright protection available in some of the unique tattoos which are being done. And then also unless there is a mutual agreement between the tattoo artist and the celebrity, that the celebrity cannot claim copyright protection over this thing, because the creator of this artwork is the tattoo artist. See, an employee in a software company who does a lot of research work, creates some software development and some data analysis, something he creates, but he doesn't get right over that particular product which he has done, because that is done in the course of his employment and under the employment and the employer contract. All works done under during the course arising out of the employment. The ownership vests with the company and not with the particular employee. Otherwise, all research work done, the researchers inside the company will start claiming copyright and start claiming patent and trademarks and other things like that. So that doesn't happen. So free online books. How do you overcome? See, a lot of people today, you get to see on Kindle, you get to see free books online available. On a lot of social websites have free online books. These online books which are freely available, most of them would be would have exhausted that protection period of the copyright of the 60-year period even after the demise of the author. So that is how those versions of those books are available on the online platform, unless the person who has copyright himself uploads these things as a social concern and as a social service. He starts putting it up online, and otherwise most of these online books which are available are because of this particular thing. Film songs also, I told you there are Film Indian Performers Society is there, where you need to take all these people who have copyright of their songs and lyrics and singing and everything, including Kishore Kumar, other singers, and all their things are empowered by them with this particular Indian Performers Society, who gives license to play these songs for commercial purposes and for trade purposes at various restaurants and things. The restaurants are taking these protection. They are taking such license. I told you I have a license copy of one of the things here. I can show you that one. And so these are all areas where copyrights can be violated for movie making. A lot of movies scripts are being questioned by somebody else as though that it was the script was somebody else's and somebody else has hijacked that particular script and started making a movie, including some celebrities were also involved in a lot of stuff, even in our Sandalwood filmdom also. Okay, so these are basically, this is just one example of a script issue which was highlighted by the media and started creating sensation when this movie was being released. Coming to the next is the trademark law. In copyright, all you need to remember is that lifespan of copyright is not mandatorily registrable. Whatever you put on an ordinary drawing, painting can become a copyright, provided that is unique from all other paintings, or nobody has done that and things like that. The trademark law, as the word itself says, is to make a mark in the trade in which you are, or a mark of yourself, mark of credibility in the market. At times you may need to have a trademark registered for the goods and services you are delivering in a particular economic zone, in both locally and globally also. Goods and services traded with distinctive identity mark. Okay, this mark can be an alphabet, it can be a number, it can be alphanumerical, it can be a logo, it can be a color, or it can be in any form of representativeness, so that it represents you in your trade, as well as it becomes an identity mark for the consumer to rely upon because of the trademark which is obtained by the particular trader. Goods and services traded with this distinctive identity. It should be distinctive from all others. What are the categories of goods and services which can be registered with the trademark registry, and what type of trademarks can be given? One is a device can get a trademark through a pictorial representation, a picture. You have got in KFC, there's a picture with the hat at a person having a hat. There is a Burger King, and you have the crown of a king wearing a crown. That crown is a symbol, a logo of that particular Burger King outlet. Then design, you can have your own unique design for that particular device, which you are selling or you are trading. This comes under even design act also. Brand, you can have your product with a particular brand. You have cycle brand Agarbatti, you have a brand McDonald has got an M as a registered trademark, okay, and it has also got a tagline which is also I'm loving it. The tagline is I'm loving it. Okay, so like that, Onida TV used to be there earlier, which the ad used to say, neighbors envy, my pride. Owner's pride, neighbors envy. That's the tagline which Onida TV used to have. So these are cheetah fight matchbox. Okay, see, it has got a picture of an animal on the cheetah matchbox. It's a one of the oldest matchboxes in India, which cheetah fight is depicted on the cover of the matchbox. So this is the brand which will identify the your trade with that particular brand, which makes it popular in the field. Heading, label, ticket, a title to your trade, a title to your product on the trade, symbols, colors, clothing. And there are several. You have Swiggy boys who are delivering, and see they have a T-shirt with Swiggy thing there. So that clothing can be a trademark for Swiggy. Okay. So Zomato, you see these people, delivery boys, who will be having a T-shirt with that Swiggy name into it. But the name itself can be taken as a trademark. Signature can be taken as a trademark. In McDowell's signature whiskey, the word signature is in the form of a sign, and as though somebody has signed it, okay, on the bottle. So that can be also registered as a trademark. Sound, and James Bond movie, the moment you hear James Bond entering, you get to see that man coming, and in the eye you get to see him shoot. But that sound also can have a trademark. There used to be a good, bad, and ugly movie sound, and whenever that sound had probably a trademark, which probably then it was also on social media earlier. Sometimes people started having it as a ringtone on once it was out on the public domain. And a word can be a trademark. Okay, a letter, number, a combination. IBM, see examples are IBM, GM, 3M, MGM, Metro Goldwyn Mayer, Metro Goldwyn Mayer movie makers. KFC, see KFC is the brand name. The name of the company which runs the KFC outlet is not in the name of the KFC. KFC is the brand name, and the name of the company which is having this is called Yummy Yummy Restaurants Private Limited or something like that. But McDonald's in India doesn't have McDonald's Corporation like in USA. The company name is McDonald's Corporation, similar to the word McDonald, which is their brand name. In India, you have two hoteliers who are having the franchisee license option, and to run this, if I remember, one is Hardcastle Restaurants and one is Connaught Hotels and Restaurants Limited, who have this rights to sub-license and allow people to take a franchisee to have these McDonald outlets, I think so. So these are all different areas of trademarks, how trademark can be given. Trademark lifespan is 10 years, renewable for similar period, unlike the copyright one, which has got a longer duration and of the trademark. The trademarks, I showed you the symbol TM. Trademark can be for goods and services. We told you the word goods and services. This is just a trademark of a service-oriented and trading company. Any urban clap. SM is the service mark. TM is the trademark. This is the service mark for or a service-oriented trading company, which is see BMW. This is the name M. Okay, and it's got a color combination. Okay. Okay, so this itself is a trademark. Okay, so the name along with this thing is the trademark of BMW. See in McDonald's, see the word R is here. Okay, this M is registered. McDonald's, this color combination is registered. This is of Starbucks. It's a trademark. TM is here. So this is how you will know that these are all sourced it from Google. You will get it from the Google. So you will know that these are visible in the same form, even at the outlets also. Trademark cases, is some of the case laws. We don't want to go too much into details of the law into it. We're just trying to tell you the gist of the cases, so that you get to understand how it is happening. Whirlpool washing machine is one of the famous cases. What happened? There was a Whirlpool washing machine in dealer. Once the Whirlpool washing machine company had closed down its outlets in India and stopped trading activity of their washing machine in India, though they were available globally other places, they have stopped their activity here. They had a registered well-known mark. Since it's a Whirlpool, it's a well-known mark globally. So people knew this mark, though it was registered outside India. Okay, the trademark registered outside India. This dealer in Delhi, I think so. This dealer in Delhi, once the Whirlpool washing machine company had closed down its business here, he started manufacturing a washing machine and gave the same name Whirlpool washing machine. Okay, and then and started selling this and dealing with this thing himself. And the moment the original Whirlpool washing machine company came to know about this particular dealer using their name, they went to court. Okay, since there is a well-known mark, to refrain this person from using this name, though they had closed down their business, since they had trademark, globally well-known trademark, so they got relief from the court so that restraining this dealer from misusing or using this name of Whirlpool washing machine. See, there is a procedure called passing off. When you have what is the protection you have? I told you, you can't sue a person if you don't have a registered trademark. So what happens when you don't have a registered trademark? Okay, under the common law of platform, you have a protection called passing off. That is, you pass off your goods as goods of another person who has a trademark. So this is called passing off. So there was an action taken by Whirlpool against this person on seeking for passing off of against this particular dealer who was there, who was trying to have a name of the globally well-known brand and Whirlpool washing machine. Honda automotive company, and he sued one individual, some Chiranjit Singh, I think so his name is. I mean, Chiranjit Singh was a person who was dealing with cookers and other home appliances. He manufactured a cooker and he named this pressure cooker Honda. Okay, Honda was the name of the pressure cooker. So the Honda company came to know about it, and though they were in different trades, see, the trade is not similar. Okay, they are in automotive business, and this fellow was in home appliances and power tools or something like that. Okay, in addition to that, so they sued him, and finally what happened, they had to the court gave verdict in favor of Honda, so and restrained this pressure cooker manufacturer from using this name Honda on their pressure cooker. You have seen a lot of prestige cooker, a lot of people start using the same format of color cover, okay, which will similarly look like as though it's a prestige product. Pigeon. Okay, when you suddenly see a pigeon cooker, you will think it is a prestige cooker. People have become, prestige has become a whole household name for several decades. So like that, a lot of similarities, distinctive similarities. See, the moment you see it, the distinctive similarity is the word P. Once you think of the word P, you will think it is prestige pressure cooker. Once you see a cooker which has got a word P there, without reading the other letters, you may think it is a prestige pressure cooker. So similarly, when you see a pigeon pressure cooker and a prestige pressure cooker kept next to each other, suddenly it may be deceptive to you, that it may mislead you to believe that is a pressure cooker of the prestige company. Okay, another case of a builder trade name. I'll give you an example. A builder in Bangalore had a trademark registered and also logo of the building. One of his project building photo was the logo of his company also. Okay, another builder who had started a new project had used the same name of this builder. Okay, and for that building which he was constructing. Okay, and a lot of people, inquiry calls used to come to this original builder who has the trademark. Okay, and assume this builder who has trademark is A, and the builder who has now started using the name of this builder A for his building, okay, is B. Okay, so what happened is this builder A was receiving calls from customers who were asking about that particular building, which they presumed that was the project of this builder A. The builder A said, no, I don't have any project by that name at all. Then this builder went and saw this building which is under construction, and he saw that name of the project was with the name of the similar to the name of his company. And since they were both builders in the same trade, property development trade, this builder A finally sued this builder B against using this particular trade name because they were in similar trade. And finally, when an arrest warrant was issued and he was asked to remove the board and he did not comply with removing the board and changing the name, then the arrest warrant was issued. Show cause why you should not be arrested, why the builder B should not be arrested. Then finally the builder B removed that name, and it was in the year end in December. So he printed a calendar for his company in which he showed this particular project which is under construction, the photo of that project which is having a different name, since he had changed the name of the name which he was using of another builder. He has changed it and renamed it, and that he produced in court. Though he produced in court, the court could have taken the builder A could have still proceeded with action because he had first violated the stay order by not removing the board and continued to have the board there in the project site. Since this builder was in the same trade, he showed humanitarian consideration, and since that builder B was a new builder who once upon a time had purchased as an apartment from this builder A as a client and then became a builder, so he showed consideration and pardoned him, and his apology was accepted in court, and the matter was closed. See, same trade but the same name. I'll give you example like you have there's to be on Brigade Road. You have earlier you had Brigade Developers in Brigade Towers building. Then you had down on Brigade Road opposite to 5th Avenue. You had a bar and restaurant, Brigade Gardens Bar and Restaurant or something. So the same brigade name was there in that, which is similar to the word Brigade Developers. So the brigade name, but they were two different trades. You have a Brigade Barber Shop on Brigade Road near Old Shule Circle, which is near the Catholic Club. Now I don't know whether it is there. So, but the trade is different. So that man can still continue to have the word brigade because it doesn't infringe the trademark of this Brigade Developers. So you can have a trademark, and if you are in the same trade and if you are infringing, then it amounts to infringement of the trademark. You can have the logo. Logo can be infringed, or the name can be infringed. The color combination can be infringed. So any one element also can amount to infringement. Nandini Milk is another famous case in our own Bangalore city. Nandini Milk, now also you get to see Nandini Milk packet, similar type of cover on some other local brand packets I have seen earlier, which may be deceptive to say that, okay, that looks like Nandini Milk only. Okay, Nandini Milk versus Nandini Restaurants. And so there was a case against them. So Nandini Milk had this trademark, but and Nandini Restaurants and so is using that name. But the court in this case, though milk is also a food product chain, and the restaurant is also coming under the food outlet chain. Though this trade area looked similar, okay, but they had distinctive similarities because that is a restaurant. The customers who come there may be different from the customers who come here for taking milk. And the court in this case said there are two different activities, and so there is no violation. As a result of which you get to see both Nandini Restaurant even today and also Nandini Milk still in operation. Okay, when it comes to same trade, if you look at the various trademarks of the category wise, you may get to see these two falling under the same category, but the court gave a distinction and in the nature of their activity. Here you don't get customers to come and sit there and drink milk. They just buy the packet, and of course today you have Nandini parlors in 9th block where there is place to sit also in Jayanagar 9th block next to James Bond dry cleaners. So infringement can be related to name. See, in McDonald's you have M, then you have the word McDonald, you have that red color, and you have the logo also, you have the tagline also. So anything, so slogan can be violated. It need not be that you may be in totality violating that mark. You may be violating one of the elements which is a part of the trademark, the color combination, shape combination, symbol combination, slogan combination, and logo combination. Any of these things you may be violating, that may amount to trademark violation. The next is the patent law. And patent law has got any research, scientific, innovative, inventive steps, inventive product which is done, and that will all fall under the patent law. You need to patent your product. But if you were to see Colors Infinity channel, and used to get this Shark Tank show. Now even India had this recent Shark Tank show. Now Shark Tank 2 season is going to start shortly on Sony channel. If you get to see it, you will get to know how this patenting happens, what is a prototype, what is a patent intent, how is the design element, what is an equity sharing, all these things you will get to learn. And being commerce students and BBA students should at least go through this. I mean, should witness this particular Shark Tank India, which is shortly going to be telecast again, season 2. And in our country, major patent are product and process patent. These are 5 category of patents and areas: product patent, process patent, design patent, plant patent, utility patent. Patent protection period is 20 years from the date of grant. Criteria for granting a patent is a novelty, something novel, innovative, inventive step involved, and industrial use. It must be put to industrial use. Okay. Novartis AG, that's a pharmaceutical company which had a patent case. You can Google it. Some element was manufactured by Novartis, and there was a case which went before the Delhi High Court. But I'm not going to go into details of pharmaceutical thing. A lot of patenting question has been raised in the recent past. In 2020 December, there was an article in Deccan Herald also which said that globally there is a cry for from the human community to suspend the patent law on vaccination of COVID, which is being produced all over the world. Don't allow patenting. See, patent, in case of patent, Government of India has got control, has got the right to take over patent control of a private manufacturer also. That's why you have seen in the Prime Minister visiting the Serum Institute of Delhi, Serum Institute at Pune, and the Biotech, Bharat Biotech also to see what is the inventive step, what is that they are doing. And government has got the power to do that, to suspend these things and take over these things. They made them sell at a subsidized rate to government, and the same product being sold at a different rate to private hospitals. That's what you got to see during the COVID vaccine time. And so patenting of a product, pharmaceutical companies, normally a lot of these research, scientific field, this patenting of a product happens. A researcher produces a plant and variety. So he gets a patent for that particular plant variety. And if the plant variety is used by a farmer in a particular method, by using different fertilizer or a particular way of growing that plant variety and getting a better yield, the farmer may get a process patent. Okay, for growing it in a particular area. Today you get to see people there was a recent article where apple tree being grown in Bangalore also. So this is something very rare to hear. You have got tulip gardens in Kashmir. You don't have tulip gardens in South India and other things. So like that, there is some area where these things can be produced. I'll come to geographical indication when I talk about these regional area plant variety and products and other areas. So product patent is when a new product is being done. The person who produces the product, I told you are working for a company and you produce a particular product in an automobile company, but the ownership and control and the patent goes to the producer, because that's the agreement between the employer and employee. He's employed you to do this research work. So the company gets the patent. not the employee. Process is the inventive steps. What are the different steps? Already there is a product which is available, but you use a different process to improve the yield of that product or improve the productivity of that product. Then you can take a process patent only for the innovative process which you did for an existing product. So that is also falling under patent law. Design will also come under Design Act. It can come under Copyright Act. A copyright drawing on paper is not a design, but a copyright drawing which can be adapted for a design on your product, on a label, like Intel. Intel has got a circle, a oval shaped circle in which Intel is there. Okay, if you write that word on a piece of paper, it just is like a copyright. Okay, because it's on a paper. But the same Intel word in that egg-shaped circle, oval circle, if it is printed on your laptop, like on my laptop here, Intel Core 10th generation, 9th generation, you get to see that logo there. So that is that word can also be registered as a trademark. Also, it's a design that becomes a design, and also design on the cover also. Okay, design not inside the product I'm talking about. You get to hear a lot of times when you buy computer, Intel motherboard. Okay, and sometimes they say Intel chipset motherboard. So they are two different things. Intel motherboard is the original Intel company motherboard, whereas the chipset motherboard, which has Intel chipset and the rest of things are different of some other thing. So that is Intel chipset Pro. So that is when you manufacture these things, the product gets product patent, the process gets process patent, even if it is the process being changed for an existing product. Design, plant variety, utility, patent, different plant variety being brought in through research in the lab can also be given, and you will get this plant variety biodiversity, the other act which is there, which talks about plant variety law. So in this plant variety law, protection of plant varieties and farmers' rights act. Okay, that's why I told you, plant variety done by a researcher, finding a plant variety, the researcher gets the plant patent. Okay, the farmer gets his rights protected under this particular act if he is bringing that plant to give a better yield in a different process which he is adopting, which is different from the process told by the researcher who invented this plant variety. So that is why I told you process patent can be different based on the process involved. Process can change, and over a period of time, the way of manufacturing coffee, making coffee has changed, and from the way you make at home is different. So you have espresso coffee, you have a lot of other varieties of coffees which you get at now. So these are things which are part of the patent law. It has got a patent period of 20 years, as long as you are able to show there is novelty, inventive step, and industrial use. If this three things criteria is not fulfilled, you are not going to get a patent protection at all. The next is geographical indication. The word geographical indication itself says geographical area. Okay, a product naturally coming out in a particular geographical area. Like I told you, tulip is available in Kashmir. Okay, Kadpa stone, the name says it's from Kadpa. Okay, red sandstone from Rajasthan. See, that's area wise. Okay, marble, Rajasthan. So these are areas. There's a lot of other areas also. So these are all goods coming from a particular geophysical area, which are culturally identifying India with the global world because of this particular product. Okay, Alfonso mango. Okay, Mysore silk sari, Mysore mallige, Mysore pak. Okay, then Banaras sari. Okay, see, these are all names of the area, geographical area from which it comes. These products will get a geographical indication tag, that it indicates that this is from a particular geographical region, which identifies this product with the culture of that and heritage of that particular area and of that country, and also brings see, these are the geographical indication is called or given to products which are invaluable treasures of incredible India. Okay, incredible India, tag on goods which create a sense of pride and essence of incredible India, which attributes to its place of origin. Kadpa stone, I told you. Okay, GI tag. products have great relevance, and though Kadpa stone has not got a GI tag, to my knowledge. Products which have great relevance to Indian culture and heritage. GI validity is 10 years. Okay. So that's the validity of a geographical indication tag. I will tell you a lot of examples on geographical indication tag. This is the GI logo which was recently created. It was not there earlier, though the act was there. Though the act was there earlier, the this GI tag, geographical indication tag, was brought in later on. Okay, so this act was in 2000. This probably came in 2013-14. Okay, this GI tag, this GI logo, which indicates it's that tag with the tagline. And okay, it has got a tagline also. So the tagline and is invaluable treasures of incredible India. This is the tagline of GI. Geographical indication. Whenever the product is given a GI tag, it has got that particular thing. The GI tag, why GI tag? Guided by law, no vendors, authentic, no middlemen, historical, specific uniqueness of the geographical region or a culture of that place, heritage of that place, or and belonging to a particular region. Okay, the geographical tag has got various categories of products on which a tag can be granted. Agriculture category, the best example is Darjeeling tea. This is the first product in India which got a GI tag. This is the first product in India which got a GI tag. Nanjangud banana, I have given you more of Karnataka product here so that you are able to identify the region along with this particular product which has got a GI tag. Nanjangud banana has got a GI tag. In the food category, Tirupati laddu has got a GI tag. Dharwad peda. See, Tirupati is the name of the place. Dharwad is the name of the place. Spices and groceries are also part of this food chain. And you have pepper, Kerala pepper, all these certain spices have got a GI tag, including with Karnataka. There are some states which have got a GI tag for a product as joint and area operators. That is from where this particular product comes. Handicraft, Mysore silk, the Madhubani paintings, different paintings can be part of it. Toys, Chanpatna toys has got a GI tag. Bronzeware, here, okay, you have in Kashmir here, the chai pot, which is that I forget the name, which has got which is a very popular one. Natural category is the marble, okay. Kashmir saffron, okay. So the saffron which is grown in Kashmir here also is is part of the natural product which is originating from a natural resource in a particular zone. Okay, the textile, hand painted fabrics, paintings on fabrics, okay, different artifacts on these things can also be a part of the GI tag category of product. Manufactured product is the other category where you manufacture. Okay, tea is grown naturally. Okay, Nanjangud banana is grown naturally. See, this is manufacture. You extract sandal oil from sandalwood, and make sandalwood soap. You have wine being made out from a particular category of grapes grown for a particular wine. Variety of category of wines are there: red wine, table wine, white wine, and you have the gold dust color wine available. You have different names available for wine. These are all things which can be entitled to get a Napa Valley wine, and different wines are there based on a particular region. So they have a GI tag also. Okay, there is a my land, my history, my heritage, my pride. I am GI tagged. I am India. This is a tag. This is a logo of an organization which is dealing with GI tag products to be displayed. If you Google, also you will get it. Recently there was an exhibition by this organization where our own Prince of Mysore, Yaduvir, inaugurated that particular exhibition, which had all handicrafts area, lot of village cottage industry products being with having GI tag to be displayed there and sold. So first GI tag in India was Darjeeling tea in 2004-5. Totally as on date, probably if you if you go through the website, you will get 417 goods have GI tag in India. First GI tag in Karnataka was Mysore silk. Mysore Mallige has also got a GI tag. Mysore Pak has got GI tag. Karnataka has got the highest number of products. Karnataka leads in the nation with the maximum number of products getting a GI tag in the country. 47 products are part of the GI tag, which are part of this thing. You will Google it, you should be able to get it. The other act is the last act is the design. I'm not going into Plant Varieties Act because of paucity of time. Design Act. A design, I told you, a copyright drawing written on paper can finally become a design and on a particular product. A copyright drawing, a design on a paper can become a design on a wrapper of a fruit product. Like there was a famous case of Britannia biscuit sauces Parle on a product which had a Good Day biscuit of Britannia, which had a smile, which has a smile as a logo on that particular packet, and similar packaging was done for a product of Parle. So they went into litigation. So they showed that deceptive distinctive similarity was there. Deceptive distinctive similarity means deceptively it will mislead the consumer to buy this product thinking that it is Britannia Good Day. Even now, I think so. I saw somewhere recently near Kengeri a small petty shop vendor selling. I asked for Good Day. He gave a biscuit, which is manufactured by, I forgot the name. I should have brought it to show it to you. So it's similar to Good Day, but the wrapper appears to be like Good Day, but it is not Good Day. It's some other locally manufactured biscuit. Okay, so that can lead to infringement of a copyright as well as design, because the wrapper is nothing but a design, and on the wrapper also, so the artwork is gets copyright, right? The design would be for industrial use on a product also. Shape, color, pattern of the packaging also falls under the IPR regime. Configuration of a dimensional form, multi-dimensional, two-dimensional, three-dimensional figure, 3D figure, all these things are part of the Design Act. But Design Act protection is a very weak protection, difficult to prove. So the visual aspects, original idea of this visual aspect was from whom, how, all this is difficult to prove when it goes to court of law. To a great extent, the copyright and trademark and patent law and plant variety, these are are having an edge over the Design Act. Design Act and Design Act and Patent Act, validity, when it comes to infringement, you go to civil court. When it comes to validity being questioned of the design or a patent, and that then you have to go to High Court for challenging the validity. Even though the case is filed initially in a civil court, once it is challenged on the ground of once you raise an issue of validity, that case gets transferred to High Court in design and patent law. So this is basically the gamut of various laws. A lot of case laws are there. Too many. If you most of the food products have landed in a lot of trademark related cases. Some of the authors have gone into copyright violation, extracting it and copying it and doing things like that. But exemptions are there for copyright. I told you, if you're using for research work, for reproducing it as a reporting material, to give comments on that thing, to criticize a particular content in a particular book. So these are all things which still are exempted from copyrights. It's under the IPR regime. There are several other plant variety. I told you plant variety. I just gave you an example of a researcher finding a plant variety and the farmer finding a different method to get the best yield out of that plant variety. He can also go into process patenting and things like that. And so this is a basic overview of all the laws. Configuration applied through different processes: industrial, mechanical process, chemical process, combo. Lot of patenting is happening under the pharmaceutical field. You are today having nutritional pharmaceutical product, so we call them nutraceutical products, like the various protein products you are having for aged people, they ask you to drink an ortho drink, an ortho nutritional drink, manufactured by a particular pharma company. A lot of pharma companies do this patenting. And there is interesting things are, once you go file a patenting application for a patent or a design, and then anybody else may take it, and before you start doing it, may get hold of that design or patent, the formula, and start producing the product directly. Okay, you may not even know. Okay, what happens is once you go to patenting, then your secret formula may be out in the domain. Okay, like Coca-Cola, till today nobody knows the thing. Coca-Cola, see, design patent, the shape of the bottle has got an IPR, or the Coca-Cola C has got an IPR or protection. Okay, the formula itself nobody knows till today what is the formula. Okay, in McDonald, M has got the thing. In Volkswagen, that V and W merged into a combination on the car. You get to see that's the logo patent, logo trademark which is got. So symbol, color, all these things can be part of the trademarks, copyright of the regime for various writings done by various authors. Okay, these are all things, playwrights, script writer, painter, enter. Okay, all these things are part of this IPR regime. There are several things in the IPR regime. I think I would like to end here. If anybody has got any questions to ask, I will be willing to clarify. It's a huge gamut with this paucity of time. Whatever justice I could do in this limited given time, I have done my effort. I hope in the simpler language to make you understand the protection period, what are categories under which the IPR can be registered, and things like that. So that is what is relevant for a commerce student, and without going into much detail. Yeah. Thank you for a patient hearing.
Thank you very much, Harish sir. Any questions from the audience, please? Any questions? You can please unmute yourselves and please ask. Okay. Thank you very much, Harish sir.
Welcome. There can be a case on airline travel. Airline and travel ticketing agency having the same name as that of an airline company can also be there, and that can also create a litigation for infringement of a trademark if the airline has got a trademark and things like that, to refrain this air ticketing travel agency from using the same, because it will mislead the passenger who comes to book a ticket at that airline ticketing agent, thinking that this is an outlet of the airline carrier itself. So that can also be there. These are several instances which have happened earlier there in our country. Thank you.
Okay. Thank you very much, Harish sir. I'm a strong believer that intellectual property rights need to be protected. A very warm good evening to one and all present here. I, Dr. Srihari, Assistant Professor, Department of Commerce, take this opportunity to deliver the word of thanks. Inventions cannot be judged on patent parameters, but patents have the ability to take inventions very far. Harish, I hope you agree. I would like to thank our today's, that is this day's day 2 resource person, Sri Harish N, Senior Advocate, Member, BPAC, and visiting faculty, SSMRV College, who enlightened about an overview of intellectual property rights, concepts, and cases. Thank you very much, sir.
Thank you, Srihari. Thank you, Anil Kumar sir. Thank you. think we're not able to hear Srihari. I think hang ಆಗಿರ್ಬೇಕು.
Sir, probably a network connection lost again,
Ah.
sir. Just we'll wait for 2 minutes.
No problem.
He
No
might
problem.
join again.
Hello.
Yes, sir, you're audible, sir. Go ahead.
Am I audible?
Go ahead, sir. You're audible.
Yeah. Thank you, ma'am. Gratitude is not only the greatest of virtues, but the parents of all others. I would like to thank the day one resource person, Dr. Ramnath, assistant professor, who yesterday gave a very good insight about intellectual property rights and its protection. Thank you very much, sir. Now, just as one candle lights another and can light thousands of other candles, so one heart illuminates another heart and can illuminate thousands of other hearts. I would like to thank our ever-charming, energetic and delightful principal, Dr. S. Anil Kumar Sir, for his all-time support for conducting these types of events. Thank you very much, sir.
Thank you so much. Thank you.
Thank you, sir. He who receives an idea from me receives instructions himself without listening mine, as he who lights his taper and mine receives lights without darkening me. I would like to thank Dr. M.S. Nagaraj, Head Department of Commerce, IQAC Coordinator, without whom this event would be just a dream. Thank you very much, sir. Thank you, HOD, sir. No duty is more urgent than that of... Thank you, sir. No duty is more urgent than that of returning thanks. I would like to thank the event coordinator, Srimati Anusha N., Assistant Professor and Convener of Unnathi, and her team members of the club.
Thank you, sir.
My sincere thanks to all departmental heads and my colleague friends, students. My sincere thanks to all. Last but not the least, thanks to all the participants. Without you all, this 2 days national level webinar would not be a success. I would like to thank our technical team, Mr. Hanumant Reddy and Mr. Ravi Raj, for their continuous support. Thank you everyone for taking the time to be here today and listening to me. I'm so grateful for this opportunity. Have a great and weekend. Now, a small announcement here. Fill the feedback form and you will get your e-certificates. It is there in the chat box. The feedback form has been, the feedback form has been shared in the chat box. The participants kindly please fill that.
அங்க ஒரு கான்ஃபரன்ஸ் நடந்துருக்கு, அது ஆன்லைன் முடிஞ்சது. 4:30 மணிக்கு ஃபங்க்ஷன். ஸோ அதை முடிச்சுட்டு 5:30 6 மணிக்கு வந்து.
Thank you, Harish. Thank you so much. It was wonderful. Actually, the examples which you have given, case studies you have mentioned, it was very good and voluminous actually. So many examples you have given. I think it was really nice. Thank you so much. Thank you, Harish.
There would have been, I mean, we need more time to give. I get a lot of such examples I can give,
Yes,
but
yes.
time is also a constraint. So we'll
because it is
more in future, no problem.
Yeah. Most of the examples from Bangalore and Karnataka, that was something great. Thank you so much.
because that brings the connect between our cultural background in the society and the city of Mysore and
Yes.
Bangalore. That's right.
Yes. Thank you, sir. Harish. Thank you.
Thank you, sir. Thank you. Pleasure. Sir.
Thank you, Harish, sir.
Thank you, ma. We can leave.
Yes, sir. Sure.
Thank you so much.
Participant feedback link has been shared in the chat box. The same, we are going to post it to your register mail IDs also. Thank you so much. Thank you everyone for
God bless
joining
you
us.
all. God bless you. God bless you.
Thank you, sir. Sarve janaha sukhino bhavantu. Dhanyawad.